In this voice thread, I'm going to wrap up the Fourth Amendment. So we're going to look at a really key idea under the Fourth Amendment, which is the exclusionary rule. We're going to look at special circumstances that limit the exclusionary rule. And then finally, we're going to look at a few sort of like odd cases, then transition towards the Fifth Amendment. So as you'll recall, the Fourth Amendment deals primarily with physical evidence, although also, with like the access to electronic communications. The Fifth Amendment is a little bit different. The Fifth Amendment deals primarily with what we call testimonial evidence, right? So this is evidence that is relayed by one party, right, who has knowledge to authorities or to another party. But before we move to that, let's wrap up the Fourth Amendment. Before we turn to the exclusionary rule, though, I'm going to talk about a couple of other important cases. So these are landmark search and seizure cases for one reason or another. So first of all, we're going to talk about Terry versus Ohio. So Terry versus Ohio, this case was decided in 1968. So this is getting towards the end of the Warren Court era. As you'll recall, the Warren Court was known for really expanding individual civil liberties, right? So this is the era in which the court really begins, especially to extend more and more protections to the right or to people who are accused of crimes. So Terry versus Ohio comes into this line of cases. So Terry is important because this is the origin of what is known as quote unquote like a Terry stop. Another term for this is stop and frisk. So stop and frisk has been around for a long time, right? This case is from 1968. It's been more controversial in recent years when people have been a bit more critical of various aspects of policing, not the least of which being racial profiling, right? So the objection being that certain people are constructed as suspicious, right, on the basis of really like racialized, biased ideas of what criminality is and what criminality looks like. So challenges to stop and frisk or Terry stops come from many quarters now on the basis not necessarily of like the doctrine behind the Terry stop, but on the basis of this idea that that policemen should be the only ones determining who is suspicious, right, or what's a reasonable suspicion. And actually, this comes up in the dissent to Terry. So I'm just going to talk a little bit about the facts and the decision, and you can kind of evaluate for yourself whether you think this fits pretty well into the broader trend of Warren Court cases, or whether you think that this is a departure. All right, so here are the relevant facts. While patrolling in plain clothes, Officer McFadden observed two men he'd never seen before, so he saw them pace along the street and pause in front of the same store 24 times. Okay, just as an aside, this is not typical, right? In most cases, you're not going to have this kind of like very clear evidence that someone is behaving suspiciously. But this is the case that came before the court. This kind of skirts a lot of the issues that we talk about in contemporary stop and frisk cases. But yes, so these two people he had never seen before were pacing along the street and stopping in front of the same store no fewer than 24 times. Very, very sneaky. So after each pass, they would stop and confer with each other. And the officer also eventually saw a third man join the first two briefly. So from these observations, he concluded that they were probably casing the store for a robbery. So at this point, McFadden approached them and identified himself as a police officer. He asked them also to identify themselves, and Terry mumbled something inaudible. The officer then spun Terry around, patted down his outside clothing, and found a gun in his overcoat pocket. He also found a gun on one of the other men, and at that point arrested both of them on concealed weapon charges. So the legal question that comes from this is it always unreasonable for a policeman to seize a person and subject them to a limited search for weapons, even in the absence of probable cause for an arrest? So the court found that no, right? So a vote of 8-1, they found that it was not always unreasonable for a policeman to seize and search a person, again, limited search, even in the absence of probable cause for an arrest. So the court in this case ruled against Terry. All right, so let's take a look at their reasoning. So first, the court asked, in this case, is the Fourth Amendment even relevant? So there was, at this point, a question as to whether or not stop and frisks even fell within the purview of the Fourth Amendment. The argument being that, while this is an inconvenience, it doesn't rise to the level of a search or seizure. So the court rejects that argument. They say that, we need to recognize that a person has been seized whenever he or she is restricted from walking away. So whenever a person is no longer free to walk away, we should consider them to at least have been seized for Fourth Amendment purposes. So thus, the Fourth Amendment comes into play, even in the slightest search and seizure instance. So here, right, in the case of Terry, there's no question that Officer McFadden seized him, and subjected him to a search. So the court goes ahead and says that we will now determine if these actions were reasonable, in accordance with the Fourth Amendment. So the next thing that the court touches on is the fact that there's no sort of like ready or simple test for reasonableness. So there's no test for reasonableness. So the court says, instead of, sort of like forging this rigid tool or test for reasonableness, what we're going to do is come up with a balance, right? So we're going to balance the need to search, right, which is the governmental interest, against the invasion that search would entail. So there is the government interest of crime prevention, right? This is a traditional, essential government interest. And so the court says this is the interest that underlies the recognition that an officer may, in appropriate circumstances and in an appropriate manner, approach a person to investigate possible criminal activity, even though there is not enough probable cause for making an arrest. So here, right, again, remember the facts of this case. They stopped in front of the same store 24 times. So they say here, it's clear that there was an appropriate basis for the officer to investigate them. So the next question that the court comes to is whether that officer, so Officer McFadden, could then rightfully also invade Terry's personal security, right? So by this they mean, did the officer have the right to pat Terry down, right, to like lay hands on him and invade his personal space? So the court says, okay, well, we're going to balance the interests. The officer clearly has an interest in his own safety. And so they say they cannot, quote unquote, blind themselves to the needs of officers to protect themselves from potentially violent situations. Okay. But then they go on to say, the officer does not need to be certain that the other person is armed. They only need to determine whether a reasonably prudent person in the circumstances would be warranted in the belief that their safety or that of others was in danger. So this is, again, a pretty expansive standard. So it leaves a lot up to the discretion of police officers. So there's no test for reasonableness. There is simply the court establishing that they will balance the interests of the officer or the state, in this case, against the intrusion that's being placed on the person being stopped, right? So note that the court seems to think that this isn't really a major incursion on Terry's rights. So one of the important points to note, okay, so from Terry, what we get from a Terry stop is that there has to be reasonable suspicion that the person being stopped is about to engage, imminently in criminal activity. The second constraint, remember, is that this is a pat down over the clothes. This isn't something that would, authorize, going through somebody's bag or like unzipping pockets unless there was, something found in that initial pat down that suggested there was a weapon. So this is a pretty limited search. But even, that said, imagine having someone who, you don't know and don't have any kind of relationship with, even if it is a police officer, approaching you on the street and, just on their own suspicion, wanting to pat you down. Would this not feel like a serious incursion on your rights? So one of the questions I want to ask is whether you think the court kind of like balanced this properly in this decision, or if you think they kind of downplayed the actual intrusion that a stop and frisk search represents. Now, there is a dissent to Terry versus Ohio. This dissent comes from Justice Douglas. And Douglas is not happy with this outcome. He says, instead, we must adhere to the probable cause standard. He says that this is the only line that draws a reasonable distinction between an officer's quote-unquote mere inkling and the presence of facts within the officer's personal knowledge that would convince a reasonable person that a seized person has committed, is committing, or is about to commit a particular crime. Right. So as Douglas says, and I quote, "We enter a new regime if the police can simply search and seize a person because they do not like the cut of his jib." Right. So that's like old-timey slang for just like not getting a good impression of somebody. Right. If you've got a sort of like bad sense of someone, think that they look suspicious. Douglas thinks this is too much latitude for this great an invasion of someone's, personal privacy. Or again, like Fourth Amendment rights. So Douglas actually kind of foresees some of these later problems that we see with stop and frisk stops, which is to say, well, we are now just relying on the judgment of individual police officers who, are members of the society that produced them and probably are prone to all the same biases that everybody else in America is. The problem being that they also have this power, right, to determine who looks suspicious and who doesn't. So the combination of having kind of like absorbed all of these structural biases with this unusual, extraordinary authority to invade other people's Fourth Amendment rights this is dangerous, Douglas says, right? And this is exactly the kind of criticism that we see today. Okay, so in the last voice thread, we were talking about exclusions to the warrant requirement, right? And so that's what we're talking about here too, right? So stop and frisk is a warrantless search. Then there is the question of a knock and search. And so this, is a much more recent case. This is Hudson versus Michigan, took place in 2006. And so this has to do also with procedure, right? So was the proper procedure followed? If the proper procedure wasn't followed, does this then invoke the exclusionary rule? So I'm going to return to Hudson versus Michigan in just a moment, but I just kind of want to like raise this so that it's in the back of your mind as we go forward. But that said, I now want to get to the exclusionary rule. Now we will turn finally to the exclusionary rule. So the exclusionary rule is the enforcement mechanism of the Fourth Amendment. So it's kind of the teeth behind all of these restrictions on what searches are legal or lawful, which ones aren't, what a warrant is needed for, what can be done without a warrant. I mean, the question always remains, well, if a warrant is required and a search takes place and finds evidence, that should have had a warrant but doesn't, what happens then? Well, that is where the exclusionary rule comes in. So this was included or was introduced in a case called Weeks versus United States. So this case was from 1914, and it applied only to the federal government. All right, so the court introduces this enforcement mechanism, the exclusionary rule. Okay, so it kind of floats in limbo for a while, right? Because it applies to the federal jurisdictions, but not to the states. And as I've been saying all along, most criminal cases are not federal cases, right? The vast majority take place at the state level or lower. So that's kind of out there. 1949, another case comes along called Wolf versus Colorado. And so Wolf versus Colorado is actually the case that incorporates the Fourth Amendment to apply to the states, right? So the way this is done is it is, interpreted through the 14th Amendment due process clause to apply not only to the federal government, but also to the states. So Wolf versus Colorado, this is part of the dicta actually in that decision. So dicta, we haven't talked about this term, but dicta refers to just things that are said. That's literally what it means. Well, what does that mean? Well, it isn't a binding part of the decision, but, sort of like concurrences and dissents, they are often referred to later. So what was actually decided in Wolf versus Colorado is that the quote-unquote core of the Fourth Amendment was incorporated to the states. Now, one of the things that they specified with this was that Yes, the core of the Fourth Amendment is applied to the states, but the exclusionary rule is not part of the core of the Fourth Amendment. And the reason for this being that this isn't actually specified in the text of the Fourth Amendment, right? It doesn't say anything about the exclusionary rule. That's kind of inferred later by the court. So exclusionary rule applies at the federal level, Weeks versus United States. 1949, Wolf versus Colorado incorporates the Fourth Amendment to the states, but not the exclusionary rule. Finally, 1961, Mapp versus Ohio, the exclusionary rule is finally incorporated to the states. So I'm going to give you a little bit more detail about this case. It's also covered pretty thoroughly in your book, but it's an important case, right? So 1961, which court is this? The Warren Court. This is often pointed to as one of these paradigmatic Warren Court cases that expanded the rights of the criminally accused. The facts of Mapp versus Ohio are pretty appalling. So like I said, this is covered pretty well in your book, but I'm going to just recap here and talk a little bit about the reasoning. All right. So Mapp versus Ohio, 1961, what happens? Well, the police tried to enter Mapp's house on the grounds that she was suspected of harboring a fugitive. That fugitive was suspected of blowing up Don King's house, right? So serious crime. She's suspected of harboring the suspect. However, Mapp would not let them into her house because the police did not have a search warrant. So the officer waited for 3 hours, and then tried to enter the house again. So this time, Mapp did not answer her door, and the police forced their way into the house. At the same time, Mapp's attorney arrived, right? So she had called him, and he tried to see her, but the police would not let him see her. All right, so hearing the police breaking in, Mapp comes running down the stairs, and again confronts them and says, "Where is the warrant?" Right? So she demands to see a warrant. The officer holds up a piece of paper, and he claimed that it was a warrant, and then he shoved it down the front of Mapp's blouse, right? So wildly inappropriate behavior. So the search turned up no evidence of the fugitive, but they did, in the course of searching her house, find some obscene pictures that were illegal to possess under Ohio law. So remember, this is 1961. This is before Miller versus California. So state obscenity laws could be pretty expansive and reach things that Miller would protect. So this material that Mapp had is found to be a violation of Ohio obscenity law. So she's arrested for that, right? So remember, this all started on the suspicion that she was harboring a fugitive. They didn't find the fugitive. They found this other thing that they then charged her with. So she goes to trial for this, contests it. The warrant is never produced, right? So the implication being that there was never a warrant, right? This piece of paper that was shoved down the front of Mapp's blouse, there's no evidence that this was a warrant. So lots of pieces of this case are just like completely appalling. But the legal question that comes from this is, does the exclusionary rule apply to the states through the 14th Amendment? So Mapp versus Ohio, they're basically revisiting the decision that they made in Wolf versus Colorado in 1949. So the court holds that, yes, in fact, the exclusionary rule does apply to the states through the 14th Amendment. And this was a 6-3 vote. So they ruled in favor of Mapp. All right, so here's the reasoning that is given. All right, so in Weeks versus Ohio, 1914, the court said that the use of illegally seized evidence violated the constitutional rights of the accused. Since then, they argued that, or they've held that standard, right, that courts shouldn't allow the use of illegally seized material or coerced confessions. They then address Wolf versus Colorado, right? So as I've said numerous times, it is rare that the court will explicitly overrule itself. They'll do it in cases where they think it's important to clarify this, right? Otherwise, they kind of present this as like, we're not overruling, we're just adjusting. And sometimes those adjustments, cumulatively, effectively overrule. This is not one of those cases. They actually say specifically outright that Wolf is no longer controlling law. Why is this? Well, They say, okay, well, in Wolf versus Colorado in 1949, the Supreme Court discussed the effect of the Fourth Amendment on the states, right? So whether or not it was incorporated through the Due Process Clause of the 14th Amendment. They ruled then that this did not apply to the states. So they say explicitly, okay, since then, many states have either wholly or in part adopted the reasoning from Weeks, right? So when he says that, he means they have adopted the reasoning from Weeks in state law. So, all right, the trend the Supreme Court has observed is that states want the reasoning from Weeks, right? They want the exclusionary rule. And so they say for this and other reasons, we conclude more generally that Wolf is no longer controlling law. They then go on to affirm that they hold that all evidence obtained via illegal searches and seizures is inadmissible in court, regardless of whether that is federal or state court. They say the Fourth Amendment's right of privacy had been declared enforceable against the states through the Due Process Clause of the 14th Amendment. Right? They say, therefore, the same sanction of exclusion that's used against the federal government ought to apply to the states. So the final point that is made in the decision is that this is an attempt to just be consistent, right? So they give the example of like a federal prosecutor who cannot make use of evidence illegally seized, but maybe across the street the state's attorney could, and that this is just not consistent, right? And so they say the state, serves, the state not having the exclusionary rule serves to encourage disobedience, right, to the federal constitution, and that this is, not serving justice broadly. All right, so this was not like a unanimous opinion, right? So it's a 6-3 vote, and it's a plurality opinion. So, as you're going through, go ahead and look at the different arguments that the justices make. See if you agree, see if you disagree. All right, so I will move on now from Mapp versus Ohio to a couple of other important search and seizure cases. Now, the exclusionary rule, like most of the things we discuss in this class, is not absolute. So there are exceptions to it. These are discussed in your textbook on page 515. I'm just going to briefly recap them here. All right, so first of all, there's a case, United States versus Calandra, 1974. And this ruling says that the exclusionary rule doesn't apply to grand juries. So just to kind of refresh your memory from what you read in your textbook, grand juries are always used at the federal level to determine whether or not to go ahead with criminal charges, right? So this is part of the preliminary process. It comes after the investigation, but before the trial. So someone has been charged, and then there's this question as to whether or not there's enough evidence to go ahead. That's what grand juries decide. So according to U.S. v. Calandra, grand juries can see evidence that would not otherwise be admissible at trial, right? So think about the effects of that, right? You might have juries seeing stuff that can't be seen at trial, but still concluding that there's enough evidence to go ahead anyway. All right, second, United States versus Leon. So this is an important case because it introduces what's referred to as the good faith exception. So this dealt with a misperception, right? A mistake. So a warrant was issued that should not have been issued. So the judge is the one who made the mistake. Ultimately, the police acted on it, and the question is whether the evidence that results from that, a warrant of that kind, could then be admissible, right? Or would this, have the exclusionary rule apply? Well, the court ruled in U.S. versus Leon that, as long as the officer was acting in good faith, so the officer believed that they were acting on a lawful warrant, even if the warrant never should have been issued in the first place, regardless, that evidence is still admissible. Okay. And the argument being that they're going to weigh the relative, triviality of good faith mistakes versus the public good of prosecution. Similarly, Herring versus United States, and it, like a warrant that's issued on the basis of erroneous law enforcement records, kind of like the good faith exception, will still be treated as a good warrant, even if it is ultimately later found to have been based on erroneous law enforcement records. So these are big exceptions to the exclusionary rule, right? So as you'll see in the cases, if you read the dissents, especially related to the exclusionary rule, many of the justices are very critical of the exclusionary rule, saying that, this is too extreme, it's too wide, it's just like too much latitude for excluding evidence when the state has a strong interest in prosecutions. In fact, this idea that the exclusionary rule goes too far had been voiced by the court many times, right? So both prior to Mapp versus Ohio and after. So, when it was created in Weeks versus US, this was already raised, right? The question as to whether or not this was like too much of a restriction on law enforcement. That was brought up again in 1926, People versus Defoe, Wolf versus Colorado. This is part of why they said that the exclusionary rule wasn't an integral part of the Fourth Amendment. And so, again, look at the dissents. Even look at the dissents in Mapp versus Ohio. There are concerns that the exclusionary rule is too much of an imposition on law enforcement. Obviously, the Warren Court's take on this would be that it's necessary, right? So the Warren Court was in part responding to police misconduct of the kind that we see in Mapp versus Ohio. But since then, the court has revisited the exclusionary rule a number of times, right? So I just talked about some of the exceptions to it. And in each of those cases, they're kind of like weighing again whether or not the exclusionary rule is worth it. And so some scholars have suggested that at some point the court may actually abandon the exclusionary rule. So what do you think about that? Does it go too far? Or is this something that we need, right? Do we only think that it goes too far because it's worked pretty well, right? And therefore we think it isn't necessary anymore. But what is your take on the exclusionary rule? All right, so one of the themes that runs through all of these Fourth Amendment cases is like the problem that technology presents, right? So technologies are changing all the time, right from the beginning, right? Olmsted was a case dealing with this new technology of, landline telephones. After this, we see the issue with like GPS. In Jones, we see questions dealing with cell site data in Carpenter. Now, there have been other technologies that have come before the court. So Kilo versus US, this is a case from 2001. This was a high-profile case at the time. It dealt with, at that time, relatively new technology that the police had access to, and that was thermal imaging. Right, so thermal imaging doesn't give a lot of detail, but what it does do is see through walls, right? So it can tell you where there are warm spots in the house. Those might indicate where people are, or, if you're investigating a marijuana grow operation that would have a lot of lights, it can also tell you where the marijuana plants are being grown. Now, that said, this comes before the court, and the question is, is this a search? Now, we don't really expect people to be walking around with thermal imaging devices, right? We don't organize our homes or our lives according to that expectation. So the court in this case found that, yes, this was in fact a search. So this needs to have a warrant. This isn't something the police can just go and do. So the reasoning that they used is that there's a sphere of privacy surrounding the home. So recall again the move from Olmsted to Katz to Jones. There's this kind of movement back and forth in terms of like what's a constitutionally protected space. So in Katz, that is specifically rejected. They say no. Fourth Amendment rights go with the person, not the place. But then in Jones, we see that place revived. And so Kilo is really a reaffirmation of that Katz plus reasoning that we see in Jones. So yes, Fourth Amendment rights do attach to people, but also places are important, right? So your home, for instance, will receive a very high level of Fourth Amendment protection. And so this is one of the things that they reaffirm in Kilo. They say that there is a sphere of privacy that we expect to have in our homes. And so having, law enforcement officers roaming around with thermal imaging devices, surveilling us without a warrant, that would be a violation of our Fourth Amendment rights. All right, so the next technology that we'll look at is actually an ancient technology, right? So Florida v. Jardine, I'm not actually 100% sure how to pronounce that, but okay, so 2013, this case comes before the court, and it deals with a drug-sniffing dog, right? So one of the points to take away from Florida versus Jardines is that, again, the court reaffirms these protections for the home, right? The home is a particularly private place. We have very high reasonable expectations of privacy there. But again, they revisit this question of technology. And so if you read the dissents say, for instance, that, dogs have been domesticated for 12,000 years. This isn't exactly a new technology. But the opinion and the concurrence points out that this is, in fact, like a specialized instrument, right? In this case, the instrument is alive, but this isn't something you expect to be kind of cruising around your neighborhood. This isn't the same as the neighbor's dog, right? So this is a highly trained dog that, again, this isn't something you expect him to be cruising around your neighborhood with. So there's similar reasoning in Kilo and Florida v. Jardine. It's just, in one case, the technology is thermal imaging. In the other case, the technology is a dog's nose. All right, so we've seen it established that you have a particularly strong sphere of privacy in your home. Your expectation of privacy is reasonably high in that place. We've also seen that the court does not recognize the same high level of protection in a car, right? For various reasons. It's readily mobile, right? There are windows that you can see in. It's, out on public thoroughfares, right? It's not parked on your private property. It's out on the street where people walking by have more access to it. So the expectation that it would be private is lower. What about a mobile home, right? So I'm bringing this up because inevitably, when I teach this class in person, somebody asks this question. And so mobile homes have been found to be primarily a vehicle. So this case was decided in 1985, California v. Carney. So the court says that they are primarily a vehicle. So again, subject to lower expectations in terms of privacy. However, they also leave this kind of not entirely settled. They leave open the question as to whether or not this is strictly an automobile. Because if it's being used as a residence, the argument from Carroll that one of the reasons that, cars get a lower level of protection is that they're readily mobile. If somebody's actually living in a mobile home, it's not readily mobile, right? They have to secure things before they take off. So the court leaves open some space here for argument. That if it can be demonstrated that this mobile home, doesn't necessarily have all of these features that make the car, less private, then there might be something in between. Also, as just a note, so your book doesn't really talk about this, and you could write. I mean, there have been entire law review articles written about this, so I'm just going to give a very short treatment here. There's a lot more to it, but I do want to point out that the Fourth Amendment doesn't reach as strongly to the border. So when you're crossing a border, you have lowered Fourth Amendment expectations. This was established in U.S. versus Ramsey, 1977. However, I urge you to read all of the citizenship literature on the expansion of the border. So, since 9/11, there's been this securitization of immigration enforcement. Some of the anti-terrorism efforts have been merged with immigration enforcement. One of the results is that the border is now huge, right? So the border stretches 100 miles. So if you look at those lines on the map, right, outlining the US, it seems really straightforward. But all of those lines are 100 miles wide, and a lot of people live inside of them. So borders are not just, entrance and exit points. They're actually large zones. Also, they apply to the coast, right? So are you 100 miles from the coast of the sea when you're at home in Charleston? You might be living in the border, right? So um, the border search exception, again introduced in 1977, lowers your expectation of privacy at the border. The rationale for this is the need to control borders, right? That the argument, and this comes up in a lot of immigration law also, the argument that sovereignty is a key right of states, right? And so border control goes along with that. And then in addition to that, there's this question of security. So your property is not secure, right? This is why this is not related directly to what is happening when you go to the airport and you submit to a search, but it's the same reasoning, right? So you don't have to let the TSA search you at the airport. You just have to if you want to fly, right? Same thing with the border. You don't have to submit to these lower Fourth Amendment rights. You just have to if you want to cross the national border. So when it comes to your property, all closed containers can be searched with or without, so it's called suspicion, but that's like a very low bar. Probable cause is a high bar, suspicion very low. Don't even need to have suspicion. So for essentially with no justification, authorities can search your property, including all closed containers. This also applies to all incoming international mail. We're also going to talk briefly now about the protections on your electronics. So I introduced this early on in the unit on the Fourth Amendment. So I have it on this slide because also your protections for your electronics are severely limited at the border. This is important if you're ever going to be working with confidential information, because you cannot guarantee if you're crossing the border with that device that that's going to remain confidential, because you are forfeiting a lot of those privacy rights that you would normally have when you bring that device to the border. So something to remember, maybe you don't want to travel with your computer, right? Maybe you don't want to travel with the phone that you normally use. All right, so that's the border. Now I'm going to turn to another case, Riley versus California. So in Riley versus California, the court ruled that authorities need to have a warrant to search or seize a cell phone, right? So this is building on, this is what Carpenter is built on, right? They argue that it's different from other property, same reasons as Carpenter. It's basically a little computer. It holds your whole life. Now, it requires a warrant to search or seize a cell phone. But what about unlocking a phone on the scene, right? Can an officer make you unlock your phone with your finger? Can they, use facial recognition without your permission? So I'm going to talk about this a little bit in just a minute, but there's actually what is called a circuit split on this question. So a lot of things having to do with cell phones haven't been fully established. Privacy experts suggest that if you want to keep your phone private, you have a code and at least 6 digits, right? So the swipe pattern, there's no definitive standard for that. Fingerprints, facial recognition, all those biometrics are not treated as, information in the same way that a code is, right? So the court has compared a passcode to like a password. And to get someone's password, you would need a warrant. Therefore, to get a passcode to a phone, you need a warrant. But the rest of this stuff is all sort of up in the air. And as I said, there's been a circuit split on it. Now, what's a circuit split? This is often an indicator that an issue is going to come before the court sooner rather than later. So a circuit split means that 2 different federal circuits have seen basically the same question come up and decided it differently. This is an indicator to the Supreme Court that on this particular issue, the lower courts need guidance, right? Obviously, because they're deciding things inconsistently, someone needs to settle this. That generally falls to the Supreme Court. So this is one of those things where we see a circuit split. Now, this is an ongoing issue. So I'm going to post on the discussion board about this, right? So we'll see if this moves forward while the class is going on. But I will post some links to the cases involved in this. Now, what I have on this slide talks about fingerprints and facial recognition not necessarily being a Fourth Amendment issue, but a Fifth Amendment issue. All right, well, remember the Fourth Amendment deals with physical evidence, the Fifth generally with testimonial evidence. So, what is different about biometrics? Well, one of the arguments, and again, this hasn't been definitively pinned down by the court yet, but one of the arguments is that when you are forced to use your own body, right, whether it's your face or your fingerprint or a retinal scan, any biometric, um, against yourself, right, it's against your best interest, then you are being compelled to incriminate yourself in violation of the Fifth Amendment. So we'll discuss this more as we move into the Fifth Amendment. But this other question then arises as to whether or not that qualifies as quote unquote testimonial evidence for Fifth Amendment purposes. So biometrics are kind of floating in this weird limbo between the Fourth and Fifth Amendments, and it's not clear which way the court is going to go on them. I'm not an attorney. I can't give you advice, right, legal advice, but I will tell you that I don't use the fingerprint lock on my phone. I don't use facial recognition. I have a 6-digit PIN. That is all I will say.